panel. That is great. 1275. House Bill 1275, please.
Thank you, Chairman Clevenger and Vice Chair Atterbury. I appreciate this cheat sheet, so I can see this ahead of me. This is very classy. I like this here. So I'm here urging a favorable report on House Bill 1275. And what this bill is seeking to achieve is essentially procedural equity and fairness as it pertains to parents with children with disabilities who are navigating a system to ensure that their children get what they need. We know that there is both federal and state mandates that public education be free and accessible no matter your ability level. So what this bill sets forth is it's not an absence of training on special education law as it pertains to the administrative law judges in our state. We feel this bill enhances and creates a more robust platform to make sure that we're covering necessary topics. So as parents, particularly pro se parents, appear navigating this system, they can be on a better footing of making sure that people understand what their needs are, both from a legal perspective and what's going on in the classroom. So more specifically, this bill requires at least 12 hours of training. You may hear further testimony about different levels and amounts of training that's currently happening, but this is not saying that you can't go above the 12 hours. It's just saying it can be no less than 12 hours. And that required training would also cover best practices in special education and also focus on trauma-informed care, discipline, and recognizing and avoiding implicit bias. I know that the other witnesses are going to have a lot more details and some data to unpack, but one of the things that I thought was really important about this bill for me is I'm just embarking on my parenthood journey with my child in pre-K4, so I'm just getting my feet wet. But I know that even when you're, you don't know what challenges your children are going to face, but every parent wants to make sure that their kid gets what they need so that they can be successful in life. So this bill, I think, is very important in the sense that we want to make sure administrative law judges have all the information they need and all the information on the current trends. And this is just an enhancement. It's not an attack on the current level. It's saying we can do more. So if people have questions for me, I'm happy to take them.
Okay. Good afternoon, Mr. Chairman, delegates. My name is Wayne Steedman. I'm an attorney. I've been a special education attorney for 28 years. Prior to that, I was a hearing officer for 10 years, a special education hearing officer. I have direct experience with over 150 hearings. The hearings, the due process hearings, or administrative hearings as we sometimes call them, typically last when parents or the child is represented by an attorney 5 to 6 days. And the reason that they go that long is because the administrative law judges are not trained in special education. They don't have a background in it. So a lot of the time you're spending your time educating the judges about what special education, what the different terminology means, what the different diagnoses are, what the different disabilities are. And for judges who don't have that background, it takes even more time. So these are lengthy hearings, 5 to 6 days. I've had hearings that have gone as long as 14 days. I know other attorneys who have had hearings that have gone as many as 20 days. By having this additional training, we believe that the administrative law judges won't need quite as much education from the attorneys, and that will make the hearings go much faster, which means we should be able to reduce the length of the hearings, and I would hopefully by more than a day or two. The hearing officers, many of the hearing officers are very, very good at what they do. As a matter of fact, I would say most of the hearing officers are very good at what they do. And I believe a lot of them are very dedicated to wanting to learn more about special education. And so they want to hear, and that's why we spend so much time educating them during the hearing. But it also means additional expense to the parents, because parents also have to then bring in expert witnesses to be able to educate the administrative law judges even more. So this bill would actually support and be beneficial to both sides, not just to the parent side, which I represent, but also to the school, because the school has to devote resources to these hearings. And if we reduce the number of days for the hearing, it will certainly be beneficial to the schools. But also, I think it would be very beneficial to the administrative law judges. These are critical decisions. These are life-changing decisions the administrative law judges are being asked to make. A child's education has a tremendous impact on his future. So these judges are being asked to make a decision, and if they don't have the information that they need to make that decision, the consequences are severe. So I think it would help the judges have a great deal more confidence in their decision, a great deal more confidence in being able to feel good about that decision when they make that decision and make the right decision for that child. Thank you.
Good afternoon. My name is Sarah Davis. I am the founder of Parent Advocacy Consortium, a grassroots organization that supports the civil rights of our children with disabilities. I am also Delegate Malone's constituent. And I'm here today because I'm the mother of 5 children. These children have a range of challenging conditions: dyslexia, autism, cerebral palsy, genetic differences. We're also an active duty military family with a single income. We had the unfortunate experience of being taken to due process by our school system when the school system did not want to identify the dyslexia that my 13-year-old at the time daughter had and continues to have. I had the very unfortunate experience of participating in the pre-hearing conference with the administrative law judge as well as with the school side attorney as a pro se parent. And although I read guidance directly from Department of Education as well as MSDE around the particular aspect of one critical point of the case, the judge then paused and said, well, I want to hear from the school side attorney. The school side attorney gave a different recommendation than what was clearly defined in the guidance, and the judge then went with the school side attorney. So what we're finding here is that because the judges do not have the depth of training in this terribly complex area of law that is constantly evolving, they are giving undue deference to the school side attorney to give them information around how they should consider or analyze a particular issue of a particular very complex case, because all of our cases are complex. And that creates a very strong level of inequity within the system. In my written testimony from Parent Advocacy Consortium, I do want to clarify one misrepresentation of statistics. Parents are losing more than 90% of the time in due process. There is something very wrong with that number, and we need to make sure that we are addressing the various underlying reasons, which include making sure that the people making the decisions are actually trained in order to be able to make a valid and unbiased decision about the case. As Wayne said, our children's futures are at stake here. While this may be just money to a school system, this is going to make the difference as to whether my child is able to live an independent life or not. This is not a trivial decision, and we deserve to have our children have the level of education when somebody is going to make such a tremendously weighty decision about their future. To clarify that previous point, if we hire an attorney and spend $50,000 or more on an attorney, we might have a higher rate of success, not less than 10%, rather closer to 25%. But which of us have that kind of money to spend? Certainly not single income military families. So I urge you as a committee to really consider this issue. It's a matter of equity. It's a matter of fairness. Our children deserve better. Our children deserve judges who have the necessary training. Thank you very much.
Hi, my name is Rosemary Kitzinger. I'm a resident of Carroll County, Maryland, and a mother of 4, 2 with disabilities. Unfortunately, I recently had the displeasure of going through due process myself for a request for assessments for my youngest son when he was 9. The due process lasted 3 days. And when we talk about money, just an example of where there could be cost savings when you don't have to explain every little detail in the due process. The board attorney made $36,578 on that due process for 3 days. A good bit of time during that due process was explaining the difference between a confidence interval and a standard deviation, or why a formal or an informal assessment, which one had the hierarchy. When there were issues that the ALJ did not understand, I watched him give deference to the board attorney and directly ask questions to the board attorney when he didn't understand. We spent a lot of time and a lot of extra effort and money explaining things that, quite frankly, the ALJ should have known, and with proper training would know. So yes, there could be a savings to the school systems as well, because they have to explain it also. This is life-changing for our children. I cannot say that strongly enough. The decisions that these ALJs are making is about our children's future. This is not about whether or not we assess or don't assess the assessment or where the child is placed or whatever the case may be on. This is about a child's future. We need properly trained ALJs. That's what we need to make these decisions for our children's future, who are also society's future. Keep that in mind. I like to keep things very simple. I am a life member at Bethesda Chevy Chase Rescue Squad. And I like to, everything in my life, I look at the medical model. So when I go to my primary care physician and I go for the annual checkup and I say, you know what, I've been having some palpitations. You know what he says to me? I'm going to refer you to a cardiologist because he's the specialist. If I say, you know what, I'm having some issues with the hernia repair I have, he says, you know what, I'm going to send you to the hernia surgeon because he's the specialist. He's still a medical doctor, but he recognizes he's not the expert in every field. No difference than an ALJ cannot be expected to be the expert in every field of law. Special education law is very different. So I urge you to support training our ALJs. I urge you to support this for our children's futures. Thank you.
Good afternoon. My name is Maureen Vanstone. I am the director of the Maryland Center for Developmental Disabilities at Kennedy Krieger Institute, which is Maryland's University Center for Excellence in Disabilities, Education, Research, and Service. I am also the founding director of Project HEAL, which stands for Health, Education, Advocacy, and Law at Kennedy Krieger Institute, which is Maryland's only comprehensive medical legal partnership that provides civil legal services to children with disabilities, primarily in special education disputes. Since the project's inception in the fall of 2005, Project HEAL attorneys have represented more than 650 students in Maryland public schools. The children that we represent through Project HEAL include children with disabilities and complex medical issues. They are coming to our institute from all 24 counties across the state of Maryland for extensive evaluation and treatment. Project HEAL is one of only a very few organizations in our state that provide low-cost legal assistance to children with disabilities and their families. The fees for our services are based on the family's annual household income and the size of their household. Most of the families that we represent belong to a very, very vulnerable group that are trying to seek access to enforce their due process rights under the Individuals with Disabilities Education Act. Part of the process of us representing these families include looking at the data and the likelihood of prevailing. Since fiscal year 2014, Project HEAL has very carefully analyzed every Office of Administrative Hearing decision in special education disputes. And what we found is that parents have abysmally low success rates in due process hearings. Since fiscal year 14, parents have won only 12.8% of all the cases, which is significantly lower than the national average. In fiscal year 17, out of 21 hearings, parents won one hearing, and the local school system won 20. In fiscal year 18, out of 21 hearings, parents won 4 cases, and the local school system won 17. In the last 5 years, no pro se parent has ever prevailed at a due process hearing. In addition to those data, Project HEAL has taken a much deeper dive and looking in at the length of hearings, both with represented and unrepresented parties, the legal issues that are being resolved, and the length of time between ALJ decisions. So the length of the time that an ALJ makes a decision in one case and then another special education case, which is about 2 years. I'm thrilled that Delegate Smith introduced this legislation, and we strongly support House Bill 1275.
Much. Delegate Erican with a question, and I'm looking for other lights. Thanks.
Thank you, Mr. Chairman. Thank you so much, Delegate and panel, for this really important piece of legislation. I have constituents who also have this exact concern, and it's terrifying that they don't know the difference between standard deviation and a confidence interval. I find that horrifying. Is 12 hours enough?
That's why you said at least, it's not
Yeah.
a ceiling,
Yeah. I had multiple people tell me that this was a problem for them and that their kids were suffering because of this. So thanks for bringing this forward to us.
If I could just also chime in on that. When I was a hearing officer before I was an attorney, hearing officers, and this is before the Office of Administrative Hearings took over the hearings, the hearing officers were required to have experience, background, training, and knowledge in special education. And then we also had to take a 30-hour course, training in special education law. Plus we had annual updates and annual training following that.
Yeah.
So 12 hours is pretty minimal.
Yeah, I mean, if you're having to explain something that basic, and these are the people that are hearing this all the time, that is very concerning for me as a parent. So thank you very much.
Enough. I mean, you have to train them almost every year because of the new things that come out in just about every field. And I know, have you ever been to the Office of Administrative Hearings out in Hunt Valley, for instance?
Oh, yeah.
And okay, I'm sorry. Of course you have. Sometimes, and I do traffic cases, DUI cases, and sometimes you get a hearing officer, and most of them know traffic stuff, okay? But the number, and then when I do other hearings, the number that know that specific area are very small. And there are so many areas like that in the law. Special education is just one of them, but, I don't know if you can train all of them for all special areas. Have you ever talked to them about having judges be assigned to specific areas on a regular basis?
Yeah, we've had that conversation with representatives from the Office of Administrative Hearings. They have
You ever talked to the Chairman Dewberry about this?
We haven't spoke with Chairman Dewberry directly. We've spoken with the other people who are in charge of the training for Office of Administrative Hearings.
Right.
ALJ Helfin, ALJ Schaefer, sorry. And the response we've gotten is that it's too difficult to schedule, to have a small cadre of ALJs because of scheduling difficulties.
Now, see, it would seem to me that you could get each ALJ trained in maybe 3 or 4 specific areas.
Yes.
That way, that person is not wasting his time. He or she is always at a hearing, and you have somebody qualified to do your hearing. And it would be up to the administration to do something like that.
I would agree.
And if I could comment, that's the one difference between it's difficult to compare decisions among the states, and it's difficult to compare. There's a number of variables that need to be considered when you're comparing Maryland to other states. But I have done a careful analysis, and the closest state that we could compare Maryland to would be Massachusetts, for a number of variables in terms of where they rank in the education system, wealth, population, number of kids receiving special ed. And the only difference in the due process hearing process in the state of Massachusetts as compared to Maryland is exactly what you suggest. They have a small panel of hearing officers that make those decisions in the state of Massachusetts.
Have you all ever done a study as to how many cases in every specific area that Maryland ALJs do, or just a ballpark estimate? In other words, I suspect that administrative hearing for transportation, for driving cases is probably the largest.
Yes.
But then what comes next, and what is the volume of each? Because maybe they need to go that way. And because look, you and I we took the bar 20 years ago. Only thing I know is criminal law. I don't remember anything about any other part of the law, unless I'm trained again to remember that,
Right.
Anyway. Thank you, Mr. Chairman.
That's another reason why I took this is because I don't know a lot about special education law. If it's not in the Clean Air Act, I don't really know a lot about it. So, it was a long time ago.
Okay. Are there I'm sorry, you have a question. The Vice Chair.
Thank you, and thank you for being here. I did have a question on the substance, which was akin to Delegate Anderson's question, because this is a huge issue for constituents in my, not just my district, my entire county. And one, they have a whole problem with the burden, which I'm sure that would be in Ways and Means. And I don't know that much about special education law. I have 3 children, but luckily I don't have to deal with it. But I think it would be a good idea to look at, and sir, where are you from?
You're asking me?
Yeah.
I'm a private attorney. I'm in
I was
Baltimore. Yeah.
I mean, to have 1 or 2 judges specialize in this area, because just like you said, I mean, one of the moms testified, I mean, these are your children. I mean, I'm not quite sure what is more important than that, and making sure they have what they need. But my real question, isn't that so? But my real question is, is this your first bill here? Is this your first bill hearing?
My first one here.
In judiciary. Okay. In that case, Mr. Chair, who else?
I don't think anyone else has. Oh, wait. Does everyone have a question? Oh, we all have questions.
Such curious
I'm sorry. Yes. We won't torture you today.
Today.
We'll wait to the voting session. All right. There are no other questions for real. Okay. Thank you all very much.
Thank you very much.
There were other people signed up favorable, but I'm not sure. Do you have any other speakers? No? Okay. That's fine. Then that concludes the proponents. As an opponent, the Chief Administrative Law Judge, Thomas Dewberry, or his representative, and his representative. All right.
Good afternoon, Mr. Chairman, Madam Vice Chair, and members of the committee. I am Thomas Dewberry, the Chief Administrative Law Judge for the Office of Administrative Hearings. I've been there for 17 short years. I do want to say from the outset that the thrust of this bill, the idea of this bill about having educated ALJs, judges in a particular area, is we totally agree with. We think that's obviously an excellent idea. Our point is, and you have my written testimony, I will summarize it. We make 2 points, is that we believe very strongly that the bill is unnecessary. Federal and state law require our ALJs to be trained before conducting any special education mediations or hearings. I have cited to the various sections, and you can see specifically how much training is required before our ALJs can conduct such hearings. Our enabling statute requires me to establish training programs and to monitor quality. It's right in the enabling statute that was passed by this legislature when it created this office almost 30 years ago. Let me tell you a little bit. All of our ALJs attend mandatory monthly continuing legal education in various subject areas. Special education topics are presented at least 8 hours and more often more than 12 hours per year. We are trained in general practices, some of the areas that are covered yearly in our monthly training are training in evidence, pro se litigants, writing. And let me go back to pro se because the one mom who testified, she is correct. Very often they come in as pro se litigants, and we probably hear more cases, because we do over 40,000 cases a year, our ALJs, large majority of them are pro se. I'd venture to say that our judges are more experienced in handling pro se litigants than any other court system in the state. Perhaps district court may have more than us when you combine all of them, but we are very experienced in that. And then, in fact, as far as education, all new ALJs that come on board attend a 4-day intensive special education seminar targeted to special education hearing officers and ALJs put on by the National Academy. If you look in my packet and it's attachment 2 for the agendas and biographies, you'll see the experts that our judges go before to learn about special education law. Again, if you take the time to read my testimony, I think you'll see how extensive the training already is. Secondly, my second point is we believe that HB 1275 really compromises the independence of our office and of my position. We conduct hearings over 30 state agencies and over 500 hearing types. No other area of law is elevated in our enabling statute like this. This is consistent with the reason for why OAH was established, to be impartial, fair forum for the resolution of administrative disputes. We do training in every area of the law, and it's central to our mission to provide fair, neutral, and competent administrative adjudication for all citizens and agencies. We believe that the best practices require that training be neutral. National training allows access to trainers who do not regularly appear before OAH as attorneys or experts in special education law. And that's very important. We need to have trainers that don't come before us because they bring their bias. We take great pride in getting national experts.
There will now be some questions, but we need to stop you there, and I'm sure.
Can I make one more point, because it's very important?
Briefly.
Very briefly. We believe that the precedent established would open the door to particular agencies or parties who regularly appear before OAH to mandate training requirements across a wide variety of subjects and limit the discretion of the chief ALJ to assign ALJs to conduct certain types of cases. In other words, it's a slippery slope. You pass this bill and we're going to have other state agencies say, hey, we want you to be educated in our area like this. We want to have only a certain amount of judges hear our cases. It's a slippery slope, and it's really against the whole purpose for which OAH was created. Thank you.
Delegate Anderson, then Delegate Arakan.
Yeah, thanks a lot, Mr. Chairman. And Mr. Dewberry, you and I have known each other ever since you were in the House of Delegates.
Way too long.
Exactly. And I do have a lot of faith in you because I've actually been before you and made some complaints, and you resolved some things. And this is the first time I've heard of, I was listening to the lady testify about how what this particular ALJ had to explain certain parts of the law. Maybe that happened. And maybe...
Well, let me tell you, I understand what she's saying. You have to remember, every case is decided on the specific facts and law of that particular case. So,
I get that part, but I'm saying is that if there were a ALJ who was more up to date in the area of special education that she had, would that person have been assigned, or is it just a random assignment of judges to? Or do you try to assign judges that know particular subject matter areas to those subject matters?
No, all our judges are what we call cross-trained. That's from the beginning. That was instituted 30 years ago when the office went into, was first created. Everybody's trained equally. And then we just have a random rotation.
Okay.
So that, we do, I think, about 25 special ed hearings a year. 300 mediations,
right,
which 75% are resolved, which I think is a pretty good percentage, where everybody comes out happy. So we do about 25. We have 55 judges. So probably, at every other year at best, any one of the ALJs would have a special ed case.
Okay. Last question, and that is, if a person has a complaint with regard to how the hearing was handled, they could come to someone in your agency.
They can write me right on our website. We have a whole explanation of how you can file a complaint.
Had any inordinate amount of complaints from any one particular subject area where your judges may not have been doing what the plaintiffs or the...
Absolutely not inordinate. I probably comes across my desk maybe 5 to 10 complaints a year over the various types of cases we do. And as I said, we do about 45,000 cases a year.
All right, thank you.
Mm-hmm.
Thank you, Mr. Chairman. Thank you so much, Judge. So 90 cases, they've stated in the last 90 cases have all failed.
No, I think she said 90% of special education due process hearings are found in favor of the school system.
For pro se, okay.
Pro se.
100% for pro se. Okay. So in my mind, I'm thinking, yeah, this just isn't working. So why can we not do what Massachusetts does, where they have specific people who are trained? Because if our judges are taking up time learning the difference between a standard deviation and a confidence interval, that tells me that whatever education they've had, they've not retained. That would be sort of medical research 101. You know what I mean?
Well, really hard for me to speak to what Massachusetts does, but if you're just talking, just to answer the question with regard to having specialized judges that only hear special education cases, again, that goes against the whole thrust of why the Office of Administrative Hearings was created. Previously to our creation, there were hearing officers in all of the state agencies to hear just those specific cases. Insurance Administration, Department of the Environment, I mean, you name it, all 30 state agencies.
Right, special.
And there was I won't go through the whole history, but there was a great deal of problems with that, and that's why it was not an administration bill that created us, it was the legislature. They heard too many complaints. The lawyers got too chummy with the hearing officers because they appear for them time and time again. I won't go through the whole history, but my point is that it totally goes against the purpose of having a central Office of Administrative Hearings.
So your thought would be that we can't tweak it and improve it because we're getting into a situation with 1 in 36 children are autistic, and these kids are growing up, and we're going to see a huge influx.
Yeah, and we've had training in autism.
Is going to increase. We're going to be seeing 100 cases, and we can't have 100% pro se losing. That doesn't feel right. So maybe there's some way we could tweak it so that maybe going forward, because of the new influx of these cases we're likely to see, we could maybe carve something out at the legislative level for you guys.
Again, my concern, I understand what you're saying. My concern there is if you do it for one, you carve it out for special ed hearings, then you're going to have the other agencies, it's the slippery slope, will be coming back and say, hey, we want this too. No, I won't say that.
Okay. Thank you very much.
Delegate McComas and Delegate Cardin.
On. Don't touch it. Okay, we're not gonna touch it. Don't touch that. So that, it's a pretty busy, hard job. Plus they have to travel to different sites and everything. So what I was kind of wondering is if what Delegate Anderson kind of suggested, if you could either have rotations that, for a year the person would deal with let's say the mental health and the issue of people getting out of the mental institutions, those hearings, because that's a very specialized area. Someone deal with the special education, someone else deal with the environment, and then, they, depending on what works, rotate them into a different area. Obviously, it's going to depend on how many cases you have of it, for the different agencies, but it just seems like to require somebody to be able to handle 30 different kinds of areas of the law, when people will hire specialists if they have a civil claim for environmental law or, having something to do with civil rights or something. And I know that there are lawyers that just specialize in special education issues. So I just kind of wondered if you would be open to kind of figuring out a better mousetrap here, if that would be possible. Because I think it creates a lot of strain on your employees, just because they have a lot of responsibility, your judges. They do. Thank you, Delegate. You're absolutely right. It's a tough job, but let me just tell you, if I did that, I can tell you that it would destroy the morale of my cadre of judges. The biggest thing that they love about the job is the variety. Some of them have come from unemployment insurance where they've done nothing but unemployment hearings. I still have some judges that go back prior to the creation of the office that were MBA hearing officers, and they love the job because of the variety.
You can do, in 1 week, you can do 3 different subject matters. And these are professionals, these are lawyers, these are people who are curious. They love the fact that they're not doing the same thing every day. I've had at least a half a dozen of my ALJs that have been appointed to the district court down through the last 17 years. And I talk to them, and while they love their new jobs, every one of them tell me, say, I do miss the variety, because a lot of, what they do is, particularly in the district court, is just very repetitive. Traffic tickets one day, domestic violence all day that day, or that week. And so, seriously, I mean that seriously, it would really hurt the morale. People love the fact that they get to hear so many different types of cases.
And former delegate, it's good to see you. And I have spent plenty of time at the Office of Administrative Hearings, mostly with MVA, employment, dollar, really not in special education. However, I'm listening to the situation that we have here today. And I just heard you talk about the fact that and how many ALJs do you have?
55.
55 ALJs.
Counting me.
And that they liked the variety.
Absolutely.
Okay. So we have to put, on the one hand, variety versus, on the other hand, competency. And you made the case that you think that you do have competency and adequate training. But the case is on the other side of, wait a minute, we're not saying that people are trying to be incompetent, but that the fact is that you need to be specialized, and if you are specialized, you're going to come out with better justice, which is what we're looking for. We're not looking for mercy, we're looking for justice. So my question is, why should we, as a legislative body, look at variety morale, which is, I understand that's your tools that you need as the director, but put your feet in the shoes of a legislator that you were in for so many years. We're looking for competency, and not just competency, but superior ability. And it would seem to me that, as Delegate Anderson was saying and Delegate McComas was saying, that specializing, I'm not exactly sure what the slippery slope that you're worried about is. So if you can just comment on the slippery slope. I guess I didn't mean to make that so
They're amending our enabling statute and saying that, and cutting out for themselves, that you're going to have the ALJ, rather than the chief determine all of this, it's going to set out, you have to do this as far as training, and here's the training, and you're going to have this committee set up, and they're going to recommend this, that, and the other. I mean, it just, you're going to have, it's a potential for other agencies to look at that and say, well, we're not happy with the decisions. We're not winning enough. We'll do what, these folks did. We'll go to that enabling statute. They've already done it. The precedent has been set. And we're going to tell them, you got to get this training, that many hours. And and what you're doing then is almost going back to the old system where the agencies, are controlling what is really the chief ALJ's job is.
Thank you.
All right. Delegate Malone, this is going to be the last question on the bill.
It'll be brief.
Okay.
So it's your discretion whether to work on a complete random basis of who gets assigned what case, rather than having, by way of example, some circuit courts have a family law rotation. Is that correct?
Right.
Okay, thank you.
Thank you very much, Your Honor. Appreciate it. And that concludes the testimony.
Thank you, Mr. Chairman.